So hello, everybody. I'm Dr. Costantino Grasso, and I serve as an associate professor in business law at Manchester Law School. In my capacity as the co-founder of the Corporate Crime Observatory, I'm delighted to welcome you to this international roundtable entitled Compliance, Avoidance and Evasion in Taxation, the Role of Professionals, the Bright Area. The Corporate Crime Observatory is an international platform established by independent academics and experts from different countries and backgrounds, devoted to promoting the analysis and discussion of corporate economic crime issues, as well as other forms of corporate responsible behavior around the world. The most relevant activities of the observatory consist of raising awareness about corporate economic crime through the constant publication of news, opinions, and bulletins, conducting cutting-edge research through the organization of scientific events having an international dimension like the one we will enjoy today, and establishing a repository of information and data related to these areas of knowledge. If you have the time to visit our website homepage, I will include the hyperlink in the chat, is www.corporatecrime.co.uk. You may enter your email address and subscribe for free to the Corporate Crime Observatory, so to get all of its new posts and updates delivered to you. Also, the observatory represents an open research environment. We are keen to create a wide and diverse community of experts, thinkers, researchers. So if you have an expertise in the area of corporate crime, economic crime, corporate responsible behavior, you have a story to tell. For example, you're a researcher, a journalist, a lawyer, an accountant, a compliance officer, an auditor, or even a postgraduate student, and you would like to participate in the activities of the Corporate Crime Observatory, feel free to contact us, and we will be very glad to explore opportunities of cooperation with you. Today's International Roundtable represents the continuation of a comprehensive research activity that has been carried out within the project Virtue, which was funded by the European Commission. If you are interested in learning more about the project, or you would like to explore its most relevant outcomes, feel free to visit the part of the Corporate Crime Observatory website, which is dedicated to it. Most recently, this research has led to the publication of a special issue, which includes 9 different articles entitled Tax Evasion, Corruption, and the Distortion of Justice in the Duke Journal of Law and Contemporary Problems, which is freely available online. The special issue aims at exploring the intimate interconnections between tax abuses and corrupt practices in the area of taxation. We will be honored to receive comments and feedback related to our articles from you. Again, I will include all the relevant hyperlinks in the chat after this brief presentation. This study has led to the organization of a series of 3 international roundtables, of which this one is the first, aiming at exploring in an innovative way the key role played by professionals in the area of taxation. The events will be structured so to focus on 3 main areas in which professionals can be placed, based on the ethics and legality of their behaviors. The first one is the one on which we will focus today, the bright area, characterized by ethical and lawful conduct. Then we will explore in the next events the gray area, featured by unethical behavior at the crossroad of legality and illegality. And then we will look at the dark area, characterized by unethical and criminal conduct. The roundtable series has been co-organized by Professor Diane Ring, who serves as a professor in law at Boston College Law School. She's also a member of the Scientific Advisory Board of the Corporate Crime Observatory, and she will be the moderator of our event today. Myself and Dr. Donato Vozza, who serves as a lecturer in law at the University of Roehampton in London and is the co-founder of the Corporate Crime Observatory. Please allow me now to thank most sincerely the esteemed and internationally renowned panelists that will offer their valuable opinions today. It is a great honor and pleasure to have all of you with us. I would also like to give a big thank you to all the members of the audience that have taken the time to be with us this Friday afternoon. It's now time for starting our afternoon of discussion and analysis. So I'm now delighted to give the floor to Professor Diane Ring. Dear Diane, the floor is yours.
Thank you very much. So we do have a lot that we'll be doing today. And to get us started, I first wanted to give everyone an overview of the structure of how we're going to be handling our panels in our session, talk a little bit about how you can engage with us by asking questions, then, of course, introduce our wonderful panelists, and then get started. As you heard, we are really trying to think about the role of tax professionals from sort of a positive perspective for today's symposium, run across 3 panels. And so the basic structures, we're going to start off with a brief case study presented by Jens Pohl that will help kind of set the context. It's just one window onto thinking about the relationship of tax professionals and how that can be fostered and developed, the issues it raises. So just a kind of brief kind of case study introduction. Then we're going to come to our first panel. And the first panel, which is be starting around shortly right after the case study, we'll look at the relationship between tax professionals and government, taxpayers, and society. Right? Then we'll take a short 15-minute break. We'll resume with our second panel. And the second panel is going to be looking at tax professionals, but thinking specifically about their ethics and their role in enforcement. Take again another 15-minute break, and we'll return for our third and final panel of the symposium today, thinking about tax professionals and the impact of globalization, capitalization, really the structure of the business. So those are our 3 panels. Very excited. And we hope that you too, as viewers today, are really interested in what you hear. And we encourage you to participate through the Q&A function, probably located at the bottom of your Zoom screens, Q&A. Please feel free to post a question there. We already have over 40 attendees, and we find people tend, it's a little early for some zones, so there'll be more joining. So it's a really exciting group. And I encourage you to participate with your questions throughout, and then we'll try to bring them forward and ask and discuss them. I'd now like to take a moment and introduce our panel. We are just thrilled with the group that we have here today, and we've actually had some time in advance meeting and talking and really engaging in these questions. I'm only going to give a very brief introduction, so to see more about who they are, what they do, what they write, where you can find more that they've had to say. I encourage you to go to the materials you've seen for this symposium, or as Costa described, the Corporate Crime Observatory website has a full listing there as well. So in alphabetical order, and very briefly again, Robert Atard, he is EY's Malta tax leader, a visiting senior lecturer at the University of Malta. He's also been the IBFD General Rapporteur on the protection of taxpayer rights. And he has published widely in the area of taxation, including something on taxation at the European Court of Human Rights. Next, and I think will be joining us shortly, Scott Cummings, Robert Henningsen, Professor of Legal Ethics and Professor of Law at UCLA Law School. He teaches and writes about the legal profession, legal ethics, access to justice. And he's also the founding director of UCLA's program on legal ethics and the profession. Next, we have with us Elaine Doyle. Elaine is Professor of Taxation at the University of Limerick, Ireland. She's a qualified chartered accountant and a chartered tax advisor. She's worked in PwC Dublin and EY Limerick before moving into academia. Her research focuses on professional ethics and risk management in tax practice, tax compliance, along with ethical reasoning and ethics education. Samantha Feinstein was supposed to be able to join us today. An emergency has not made that possible, and we look forward to working with her again. Next, we have with us Maria Amparo Grau Ruiz. She is full professor of tax law at the Complutense University of Madrid and a visiting professor at Northwestern University. She's also director of the research group Law for Sustainable Development, Socially Responsible Tax, Labor, and Administrative Measures. We also have with us Henry Gresh. He is currently lead manager on the tax practice and ethics team of the AICPA. And over his career, he's had leadership positions in regional, national, and international firms working on international compliance and planning issues. His current responsibilities at the AICPA include acting as the staff liaison to their Tax Practice Responsibilities Committee, the Statement on Standards for Tax Practice Revision Task Force, and the Circular 230 Revision Task Force. We also have with us Mary Inman. Mary is a partner at Constantine Cannon's London and San Francisco offices, and she heads the firm's international whistleblower practice. She specializes in representing whistleblowers worldwide under the U.S. Whistleblower Program. And she, for example, represents the renowned SEC whistleblower Tyler Schultz, who exposed the Silicon Valley blood testing startup Theranos. Next, we have with us Nina Olson. She is the executive director of the Center for Taxpayer Rights. It's a nonprofit that works to advance taxpayer rights in the United States and internationally. From 2001 to 2019, Nina served as the National Taxpayer Advocate in the United States at the IRS. That was leading the Taxpayer Advocate Service, an independent organization, but within the IRS, dedicated to assisting taxpayers in resolving their problems and making administrative and legislative recommendations to mitigate those issues. Daniel Ostis joins us. He's the James G. Harlow Jr. Chair in Business Ethics at the University of Oklahoma. And he's taught business economics, business law, and business ethics, both the undergraduate and graduate level. His research addresses the economics of marketplace ethics and the ethics of corporate legal strategy. Jens Pols joins us, serves as a non-executive director and audit committee chair in several medium-sized companies with global activities. He works as an expert witness, and arbitrator in international arbitration proceedings. And he is a member of the International Ethics Standards Board for Accountants, the IESBA, since January 2018, and is chairing their tax planning and related services task force. And then finally, Carlos Vefe joins us. He was a former senior research associate and scientific coordinator. He's a coordinator at the Observatory for Protection of Taxpayer Rights, the IBFD. He's been associate professor and former chair of public finance at the Universidad Central de Venezuela, and professor of taxation and human rights, Universidad de Montevideo. Not sure I got that right. And also representative for Panama to the board of directors of the Latin American Institute of Tax Law. So I hope you hear from across, and the reason I want to take just a moment to read even just the brief bios is to give you a sense of the scope and range of work that our panelists bring to today's conversation. We thought that was really important. We're hitting hopefully lots of different kinds of practice, experience, from firms, from in-house, from advisors, from government work, from academia, really touching upon every kind of topic. And the idea today is really a roundtable. We really imagine, you think of the sort of Zoom screen, on the gallery view as if we were all sitting around a table discussing some really important questions. And so we're putting them out there and hearing each other's perspectives, feedback, push a little bit on what people are suggesting or have to say. And that's really our goal today with such a distinguished group. But to begin us for this first session, Jens, I'm going to turn it over to you for our case study. So you can take it away.
Thank you, Deanne. I'm just trying to share the screen. I hope you can see all the screen now. Thank you. Thank you for this kind introduction. I feel very privileged and honored to give a short presentation on some thoughts the International Ethics Standards Board for Accountants has done and in the last few months. And the project is called Tax Planning and Related Services, and it is driven by some global policy discussions about the role of the profession, the tax profession, and in this context of the accountants doing tax advice, in questioning which is the role of an accountant in tax planning circumstances. And it is about the question, what does it mean that an accountant has to act in the public interest? And in each and every jurisdiction, there is a similar notion for tax lawyers or tax advisors that they are acting somehow in the public interest. But what the hell does it mean in a concrete situation? And that is a little bit the issue we have tried to discuss with stakeholders. We had have had many outreach activities, and the outcome will be an exposure draft of adding something to the Code of Ethics of IESPA, and the exposure draft will be released in the next few days. So it's a very actual presentation I will try to give you. I will start with some headlines, and these are cases, but you could take in each and every jurisdiction other cases, which are a little bit the background for our project. And I feel it very interesting that you have organized these roundtables with the 3 chapters, so to say, the bright, the gray, and the dark. For me, the question, or for the whole board, the question is, where starts the gray zone, where ends the gray zone? So it's a little bit broader, perhaps, because this borderline is not so clear as it might be, or should be, or we would like to have it. So I will just try to illustrate it with the Starbucks case. You all know I don't want to go into details. It's a perfectly legally structured, but nevertheless, there was a big outcry. I think it was in 2012, where the public has addressed their reservation about the very low taxation rate, which was in UK. And I think there was some campaigning against the shops, etc. So there was a reputational issue out of a tax structure, which seems to be perfectly right. Another issue is about a very recent case from Australia, where a partner of the Big Four was banned for 2 years in Australia for sharing confidential information about government plans to target multinational tax avoidance, whatever avoidance may mean. It's again in the gray zone, and he shared this information with the firm's clients, and there was a procedure, an ethical procedure afterwards. So what the IESPA is trying to propose, it's an ethical framework for doing tax advice as a professional accountant. I have not the time to go into the details and to present everything, but I just want to give some headlines. So, for example, comply with the fundamental principles, exhibit the mindset and behavior expected following the role and mindset provisions. This is a special chapter in our code to demonstrate what does it mean to be a proper accountant, and that includes be a proper tax accountant. Another issue is to review the legislative intent, to look at the economic purpose and substance of a transaction. Very important to exercise professional judgment, to establish a credible basis, a term I will come back in a few minutes, to consult, to communicate, to evaluate, and that means to be transparent and to have a proper documentation and very clear. I just want to say that at this stage, respond to suspected non-compliance with law and regulation. We have a chapter in the code which makes clear what does it mean. The key proposals in our exposure draft are to describe the role of the PA in acting in the public interest, the necessity to develop in the tax advice a credible basis, and then to give some consideration of the overall tax planning advice or recommendation. We call it a stand-back test, and some additional changes to the code in application of the conceptual framework, and specific requirement on disagreements. What happens if the tax accountant is in disagreement with his client? The main point I will concentrate here is the PA's role acting in the public interest. We are not defining the public interest. Why not? Because we detected that they are in each and every jurisdiction, you have a different public interest. So we have public interests, plural. And as a global standard setter, it's not possible to define it on a global level. But we have stated some descriptions. For example, we acknowledge that a large part of acting in the public interest is to assist clients or employing organizations to comply with tax laws and regulations. We have heard from many stakeholders, without tax advisors, the whole tax systems in many jurisdictions would not function. So the PAs play an important role rather than assuming the responsibility of ensuring compliance with tax laws and regulations. And we are not only talking in our code on tax advisors working in public practice, but also accountants in business. So we recognize that clients and employing organizations have a responsibility to pay their legally assessed tax dues, but we add that there is a reputational risk to clients and employing organizations and to the profession, which are important considerations which has to be looked at. Another point, the credible basis. We are saying in each and every tax advice, the professional should have a credible basis. What does it mean? It's not that in a certain tax structure, he's 100% sure that this structure will prevail a court challenge. But we are clarifying that a PA has to develop an arrangement, and he can only advise his client if he has found a credible basis for his proposal, to avoid misinterpretation that this provision is prohibiting a PA from engaging in any discussion. We are saying it is allowed to discuss with your client and determine why there is or is not a credible basis. And we have added a lot of application material on that. What is a credible basis? Is it 50%? Is it 25%? We are not giving numbers here, because also we have heard from many jurisdictions that there are different ways to find a credible basis in certain jurisdictions. We believe that a credible basis must ultimately be anchored to the relevant tax laws and regulations, and hence we develop this credible basis in laws and regulations, which means that there is a realistic chance to stand. Very important, we looked at some guidance material, how to find this credible basis. So one factor, we are not saying that is the only factor or the main factor, because different legal systems, continental, European, Roman common law system have different interpretations of laws. But we are saying that the intent of the law is a very important point. We also introduced a stand-back provision if there is a credible basis, because we are thinking that the role of a professional accountant doing tax advice is more than just saying you have a credible basis in tax laws and regulation. Because the Starbucks case demonstrated there was a perfect basis, credible basis in laws and regulation, but there was something else, a reputational, commercial, or wider economic consequence, which probably should be part of the advice of a professional. So this is a good faith consideration based on PA's knowledge of the context and circumstances at the time. So that is a little bit the scope of this paragraph. It's not about tax morality or social justice. It's just widening a little bit the scope and standing back and looking at the advice and the possible reputational or wider economic impact. So we tried in our proposal to find a guidance and navigation for the professional accountant doing tax advice in this area. And you see that's a little bit very similar to the Roundtable's organization, clearly legal, gray zone, and clearly illegal. But the ethical considerations are, and the conceptual framework applies in all three areas. Because if you're in the clearly legal area, there are certain requirements you have to follow in the consultation, in the advice for your client, and even in the clearly illegal part, what to do, inform those charged with governance, etc. We have added to the code some examples, some further actions and safeguards for eliminating threats or for bringing the threats to an acceptable level. That's another part of our proposal. And last but not least, we are talking about disagreements. So we are clarifying the sequences of steps a PA should take if there's a disagreement with a client. We are clarifying that the circumstances is about a disagreement over a tax planning arrangement the client wishes to pursue against PA's advice, what to do. And we want to avoid inadvertently limiting the client to an entity. The client could be an individual too, so the scope is broad. And we try to encourage the professional also to document his communication and to consider even a communication with those charged with governance. So this is in a nutshell our proposal, and you see here our timeline. We have approved the exposure draft in December in our board meeting in New York, and the publication will be in the next few days, and there will be a 90-day comment period, and then hopefully we will be able to have a final approval of the pronouncement in December of that this year. So that's my short intro. Thank you very much. Back to you, Dave.
Thank you. Thank you, Jens. It was, I think, really helpful to start us off to actually sort of have a case study that sort of looks at an effort to address the kinds of questions that we're covering today and then in subsequent sessions for tax advisors. And, you know, as we'll be talking about today, our tax professionals, they really are crucial intermediaries and the focal point of different and often competing interests, whether it's clients, state, society, and it can be difficult to balance. And so I think, you know, this is a really great way for us to start our first session. So